Hope everybody's doing well and everybody survived the big blizzard. Welcome to the February 2026 LIBOR Legal Update. My name is Patrick Fife. I'm LIBOR's General Counsel. Just as I do with every class, every legal update class, I always just like to give you a quick reminder. Make sure that you are regularly checking out LIBOR's website. Make sure that you're signing up for our emails. A lot of the material that I cover every month is on the website. It's in our weekly email. Every week, we send out an email on Thursday, has the free weekly legal tip, has access to or links to different webinars that we've put on, information about events. So please make sure that if you're not getting that email, you do. It's a really great way for you to stay on top of changes in the law, new trends, new things happening in our industry. Because taking this class once every 2 years, it's just not enough. There are so many new developments that all of you need to be aware of in this industry, and I think the only way to do it is to stay on top of those new trends, new developments, is to have a system. And that's why we try to give that to you. We give you that weekly update so that you can just plug yourself in every Thursday morning, make sure that you are on top of things that are happening, new trends, new developments. Um, Again, our website, lirealtor.com, all the legal tips are on there. So if you do miss a weekly email, you can go there, check them out. I will refer a couple times today to some of the articles that are on the website. That way, if you want more information about some of the topics that I cover today, you can just go there and check it out. In addition, a lot of other great material on there. The one that I would like to highlight for you that I hope you all take advantage of if you have any issues um, with another realtor, complaints, whether they're monetary, whether they're just a communication breakdown, take a look at our dispute resolution center. In addition to filing an ethics complaint or an arbitration, we have an ombudsman service. And basically, opportunity of free service to have a neutral third party facilitate a resolution if you've got a breakdown in communication. Again, all the information is on the website. Just look under legal, and I encourage all of you to check that out. Lastly, just want to remind everybody that LIBOR has a legal support center, legal helpline, available Monday through Friday, 9 a.m. to 5 p.m. The number is 631 4800, and it's extension 335. So feel free to give that a call if you have question concerning real estate related matters. One just housekeeping note before I really get started onto the content. If you have questions today, just put them in the chat. Please try to stay on mute since we've got a pretty large class. I think we're over 50 people now. So it would help me if you have it. I have the chat open. I will see questions. And if you have questions you want to ask of me in person, I'll stick around once the class ends and can answer those afterwards. All right, so I mentioned the Legal Support Center. Let's talk a little bit about some questions that came in this past month. I like to do this for a couple minutes before each, or at the start of each class. And this question I covered last month. I just kept it in there because I liked the picture. It reminded me of what we faced just the last couple days, but has to do with trees on a boundary line. And what are the rules? And I don't encourage you to certainly, make a determination here. If there is a tree on a boundary line, but you just need to know generally what the law is. And that is if there is a tree on a boundary line, it's owned by both parties. Neither party can remove it, cut it down, or damage it without the other party's consent. If there's a tree overhanging, branches, things of that nature, um, one owner or the owner where the branches are overhanging can trim it, but they can be liable if they harm the tree's health. So my guidance on this is if the issue comes up, have your client consult with their attorney regarding issues about removal, property line issues, Certainly encourage them to look at the survey, but at the end of the day, make sure that they consult with an attorney before taking action because one thing you should be aware of, if you cut down someone else's tree, the damages can be substantial. There's a law in New York that provides something called treble damages. And if you cut down a really old tree, guess what? A really old tree can be really expensive, and treble damages means it's triple the damages. So it can be a very costly mistake if your client cuts down or damages someone else's tree. Um, Another question. This one specifically hadn't come up, but I tweaked it a little bit just for what we're dealing with outside right now. So, question: who's responsible for clearing uh, snow and ice before a showing? Well, the answer is in almost all cases, it's going to be the property owner who is responsible for snow and ice removal. If the owner's absent, I know some of you take listings, you might have a vacant home, somebody who's relocated already, it's an estate. You should let the owner know to hire a snow removal service. Document that you advise the owner that they should be clearing snow and ice. I do not recommend that you personally take on snow removal. That can create liability for you. So best practice, if there is a situation, let's say you had a showing today and the owner was out of town, and there's 2 feet of snow leading up to the walkway. I would make sure you cancel that showing or delay it. Really the liability could be if you obviously try to have a showing where it's an obvious dangerous condition, that the property was unsafe, or that you tried to rectify it yourself. And again, that's why I don't recommend that you take on that responsibility. If you do, you could be taking on liability. Um, I see some questions that have already popped up. Somebody going back, Alex had a question about the tree trimming and isn't that called an easement? And an easement's something a little bit different that gives one property owner a right to, in some cases, access or use, whatever it might be, typically access over someone else's property. Again, questions come up about easements, things of that nature don't go beyond the scope of what you're permitted to. Legal questions should be referred to an attorney. That's going to be a theme, something that comes up later today. Um, Someone else, Renee, asked about snow removal. If it's noted in a lease agreement that it's the tenant's responsibility, is that okay? Yeah, that's certainly okay. If it is the tenant's responsibility. But again, my guidance here is just about if there's a showing coming up. Certainly, I would not want you as the listing agent to take on that responsibility. Whoever's responsible for it, make sure they're aware of it if a showing is coming up so that the property is cleared. And if it can't be cleared, my recommendation is cancel or delay that showing. Question, this is more an MLS rules question. Remember we have a rule in our MLS about offer acknowledgments, and often this question comes up. Listing agent sent an offer and acknowledgement and the seller won't sign it. What do you do? There's a rule for that. We have an MLS rule, 406.4. I encourage all of you just take a quick run through. It doesn't take long. Get familiar with our MLS rules. They're pretty straightforward and easy to understand. They're organized really well. But if you get presented with an offer acknowledgement form, the owner refuses or is unable to sign it, there's a rule for that. You have to provide a sworn declaration statement stating that the offer was presented to the owner. It's signed by the listing broker or any licensee in that listing broker's office. And then you return that to the cooperating broker along with the offer acknowledgement form. Again, really straightforward. I know the MLS One Key gets questions about this often, sometimes our legal support center. Um, MLS rules again, they're available online, really easy to follow. So if you have questions about it, take a look at the rules. We get a lot of questions to the Legal Support Center. I've also gotten a lot of questions in classes about advertising, and I'm going to cover advertising a little bit later. But what about joint advertising with, let's say, a title company, an attorney? Can you do it? The answer is yes, you can, but there are very specific rules that you need to follow and make sure you're following when it comes to joint advertising. Something called the Real Estate Settlement Procedures Act. It's also known as RESPA. It's a federal law, and it prohibits giving or receiving anything of value from another settlement service provider in exchange for referrals. So what's a settlement service provider? It's anybody who provides services in connection with a real estate closing. So it could be a closing attorney, a bank, a title company, a home inspector. You, as real estate licensees, are settlement service providers. So you're going to ask me, well, what does that have to do with advertising? Well, let's just say you have a joint marketing agreement and they're you're advertising together, but the other party you're advertising with isn't paying anything. Under RESPA, that's considered receiving a thing of value. That's a violation. The government could say that's you're disguising it as referral compensation. So if you're going to advertise jointly with another settlement service provider, both parties should be paying or need to be paying their fair share of the actual cost. Um, it has to reflect the fair market value. So um, let's just say there's an advertisement where one of you is jointly advertising with a mortgage broker, and you're both highlighted in the ad, and your services are both highlighted in the ad, and it's equal. Well, you should each be paying 50% of that. That's equal cost, equal space. That's you want to make sure that there's a proportional contribution by each party to their share of the advertising. If there's not, and one party's subsidizing it, so let's just say the mortgage broker says, "Hey, you know what? I'll pay for this advertising. You don't have to contribute anything. I'm going to highlight you." That's a RESPA violation. Government could look at that and say, "Look, that broker is paying for you to be advertised to get referrals," and that's illegal. You cannot under RESPA anything of value in exchange for referrals is prohibited. If you have other questions about RESPA, look at our website. We just did an article on this, provided a link to a lot of good materials from NAR, FAQs, things of that nature. Please take a look. It's an area where I think the government, not even just the government, but sort of plaintiffs, attorneys, class action attorneys could be looking down the road. There's been some RESPA lawsuits that have been highlighted recently in the media. Just be careful. If you have any kind of joint advertising like this, make sure if you're a salesperson, you're checking with your broker, obviously, because broker has to approve advertising. And brokers who have any kind of joint sales agreements like that or joint advertising agreements, run them past your attorney. Make sure that they are compliant with RESPA. Another question that's come up, you may have read about this, a new FinCEN rule. A couple of you may say, what the heck is FinCEN? What is that? It is the Financial Crimes Enforcement Network. It's a federal agency. It's part of the Department of Treasury. And there's a new rule that came out, and it begins on March 1st of this year. And it says that basically certain professionals involved in residential real estate closings have to report information about all cash transfers that are made by legal entities like corporations or trusts. So there are specific disclosures that now need to be made if there's an all cash purchase by a trust, by a company, and these disclosures need to be made to the federal government. This doesn't directly impact you because typically real estate licensees aren't the party reporting the closing. It's typically going to be the closing agent, the real estate attorney. But the reason I'm just letting you know is that if you have buyers in these types of transactions, you should at least let them know that they are going to need to provide additional information to the closing attorney. You want to make sure that they're aware of that so that there aren't delays with the closing. It's just a good piece of information to know. So if you're dealing with a trust, you're dealing with a corporation as the buyer, make sure that if it's an all cash deal, you're just communicating to them that there is this new rule. They should speak to their attorney. There may be some information that they have to provide. And this does not, yeah, Jolie asked about trust corporations. Yeah, certain entities, it doesn't apply to individuals, but just make sure that you're aware of this. Again, we put out a legal tip on this, I believe, last week. So take a look at that if you have any questions. Another question. This one came up, I guess, last month, and we did put out a legal tip on it. What happens if your license lapses? I guess it can happen. You hope you get a lot of reminders, I know. Is there a grace period? Will Department of State say, "Oh, don't worry about it"? Attorneys actually do have like a 30-day grace period, not to let their license lapse, but to submit their registration renewals. No grace period for real estate licensees. If you let that deadline lapse, you cannot work. You are not allowed to continue working while you're unlicensed. So if your license renewal date is coming up, get that application in. You have to do it every 2 years. It requires the completion of your required CE. Make sure that you submit it on time. If it does expire, you do have 2 years to reapply without retesting. But again, it's definitely going to take some time to get your application approved. So please make sure that you don't sleep on that deadline. All right. Now we're going to just move into a couple of additional topics. This one I've covered before, but I put continued major warning. It's just something that continues to that you all need to have on your radar, and that's cold calling. If you've taken this class anytime in the last couple of years, you know that you've been told before. There's a law in New York State that said anytime we're under a declared state of emergency, no one in the state is allowed to make cold calls. It's a law. It's been on the books since before 2020. And right now we're under three states of emergency. I think I said last month you wouldn't believe we are. Maybe now you would because given the winter weather, that's one of the states of emergency. They extend all the way into at least March. They'll probably be extended. Many of these states of emergency, they're declared by the governor, have been repeatedly extended. If you see those numbers, CEO 47.15, that state of emergency for public order at correctional facilities has been extended 15 times. That's what that 0.15 means. So we've been under a declared state of emergency for several years under some of these different states of emergency. So that means no one can make any unsolicited phone calls or text messages to a member of the public. Any other kind of marketing is allowed. Now, I know some of you are saying, well, I get cold calls all the time, and I know that might be the case. I caution all of you specifically because the distinction here is you have a license from New York State. That means you're subject to supervision by the Department of State. If the Department of State gets complaints about cold calls from real estate licensees, they will look into them. And they have been. And the fines for violating the general business law restriction on cold calls during states of emergency is up to $20,000 per call. That can add up really quickly. There's a reported instance where Department of State was seeking to hold individual licensees liable for over $13 million in connection with over 250 allegedly improper cold calls. Question, what is a cold call? Well, it's a unsolicited call to a member of the public that you do not have a pre-existing business relationship with, or an ongoing business relationship with. So, you just calling up individual people or texting people. who you've never done business with, or you have no relationship with, you don't have a current relationship with, that would be a cold call. Getting a list of potential leads, calling them up, that's considered a cold call. It's not allowed during a state of emergency. Um, Calling on expireds that you were not the somebody just asked, if you're not the previous broker, who had that listing, and you have no relationship with that homeowner, that is a unsolicited phone call. So be careful because it could expose you to liability. The law stinks. Don't shoot me as the messenger for this. I think the law is terrible. I don't think this was the intended consequence. Um, our New York State Association of Realtors has been lobbying extensively to get this changed. I hope it will get changed. They've been trying for the last couple of years. It's like pushing a boulder up a mountain because a lot of legislators aren't really in favor of changing laws that allow for more cold calls. So what can you do about it? Well, there is some legislation that is potentially uh, pending, trying to get it pushed through. Support any calls to action by NYSAR. They're urging the state Senate to prioritize this bill. So if you get a call of action from NYSAR, make sure you sign up for it. Make sure that you communicate to your state senator that you believe that this law needs to be changed, um, and 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 make it a priority. Um, I see a couple questions here. Somebody has, what are the states of emergency? I covered that a couple slides ago. We're under three right now. One related to winter weather, one about correction facilities, one about I think still vaccine mandates. There are still, again, unless you hear from NYSAR and LIBOR that the states of emergency are over, we're still under one. We will let you know once there's no longer a state of emergency or cold callings allowing. And I know some people out there are doing it. There's no way around it. The way they're taking a risk. And I warn you that you are taking a risk if you cold call. You can do it. You're putting yourself at risk, and it's up to $20,000 per call if somebody were to report you. So that's why I want to make sure that you're aware of this. And it's a New York state law. It's not a federal law, New York state law. Also, just be aware, and I'm not going to cover this extensively. Once cold calls are allowed again, legally allowed in New York, there's a whole host of new restrictions that you need to follow in order to make cold calls. And that includes identifying your name, the company you represent, the purpose of your call, letting the caller know if your call is being recorded, and offering the caller the option to be added to the company's internal do not call list. And you have to do that all within the first 30 seconds of the call. So once cold calls are allowed, really important that you make sure you're following the law in this respect, because that can also lead to a $20,000 per call fine. Don't forget, too, there's a do not call registry at the federal level, and it's enforced by the New York State as well, and that you cannot call numbers that are registered on the do not call list. And if you do, that can be a significant fine as well. So, bottom line, if you're a broker, I encourage you to have cold calling policies in place. If you're going to allow for cold calls, have guidelines, provide recommended scripts, but also make sure that until the law is changed or the states of emergency are lifted, you're not making cold calls. And if you are, you're taking a pretty substantial risk. All right, next topic I'd like to cover is just use of attorneys for closings. And this came about, there have been some reports. NYSAR, which is the New York State Association of Realtors, had gotten some reports that some licensees were recommending that parties use the services of a closing company or a title company instead of legal counsel to facilitate a closing. And these title companies, closing companies, were not providing legal representation. They were just using paralegals to complete paperwork and attend closings. Think this was more upstate. But I'm just putting a caution out there to all of you. I do not think it's good practice to recommend the use of a closing company if that company is not providing legal representation. You have a duty to act in the best interest of your clients and be honest and trustworthy with customers. So I think best practices you should always, in really any capacity, and I've said it before on some of the other issues we've already covered, I strongly recommend, and I'm not saying this just because I'm an attorney, right? I'm saying this to protect you, that you should recommend that clients and customers retain an attorney to represent their interests. And if you don't, you can potentially be in breach of your fiduciary duties and New York licensing law. Um, Also, you can't provide these services, right? There are certain things in connection with the closing. So whether it's drafting the deed, completing really any of the tasks that normally an attorney would engage in, reviewing the title report, things of that nature. If you do those, you can be subject to discipline from DOS, just as if you recommend a non-attorney to do those things. So really make sure that I think it, without a doubt, you want to make sure that you're recommending that clients and customers utilize an attorney, um, and not to engage in any kind of workarounds in that respect. So just a warning on that, given it's something I know that's been reported to NYSAR, again, more upstate, but just making sure that you're all aware of that caution as well. Another topic I want to just let you know about is a recent warning from the New York Department of State regarding AI, artificial intelligence. AI is great, right? There's so many uses that I'll say productive uses. There's a lot of unproductive uses out there. I've seen people get carried away with, but a lot of productive uses that all of you can use in connection with the things that you do. Whether it's creating listing descriptions, helping you with your marketing, enhancing your listing content. Um, it can really be a useful tool. There are some major risks with AI. I'm not going to go through these in detail, but certainly AI can be inaccurate. Um, there are certainly fair housing issues that can come up with AI. Just creating a listing description, right? I've seen it. I've played around with it. You put in, give me a listing description for this particular property, and the description comes out saying that this property is great for families. That's a fair housing violation, right? AI doesn't necessarily take into account all of the things that it needs to do. It doesn't always give you output that complies with different laws. Even with specific prompts where you say, provide me a listing description that's compliant with New York State and fair housing laws. It's not 100% accurate. So there's certainly risks associated with it. You should not be using AI for anything that is your responsibility under the licensing law, and that includes creating listing content. You need to review it. You own it. It's yours. You can't use AI as a defense. Um, you need to make sure that anything that you use AI for is honest, that it's not misleading, and if you do use AI, all of these laws apply. So your advertisements still have to be honest and accurate. You can't engage in deceptive acts or false advertising. Um, so there's no specific law that exists in New York concerning the use of AI or even in the use of AI in connection with real estate, but all of these laws would apply to your use, at least generally. So I mentioned a warning. So New York State Department of State put a warning out in November, and they really warned it was both home buyers and real estate professionals about the use of AI in real estate listings. And they mentioned that it raises potential concerns with false advertising. And here was the big part of the warning. Um, the Secretary of State in New York said AI can help home buyers imagine what potential homes look like, but these automated technology tools may produce misleading or exaggerated representation of properties. I urge real estate agents to be mindful when listing and consumers to be vigilant when searching for their dream home. I highlight that because that to me is a signal that the Department of State is looking at this and they provided all of you a warning. And to me, that means that if you do use AI in a way that creates something that's misleading, the Department of State can now say, look, we warned you. You disobeyed our warning. We're going to discipline you for it. So I do see this as an area that Department of State is going to potentially discipline anyone who uses AI in a way that creates misleading advertising. They also highlighted that, you should really think, given the risks of using it, is it really help? They cited a recent study where said that a lot of consumers actually distrust AI generated images and perceive them as less authentic, especially when it comes to high involvement decisions like buying a home. So, just something for you to consider. Another part of their warning is AI is being used to impersonate licensees. I think I've seen this. I've gotten some calls and some complaints that members have said, their basically likeness is being used by someone else to list properties, identity theft, things of that nature. So I caution all of you, this is separate from, your use of AI. Um, do a routine check every month. Just search social media, do a Google search of yourself. Just takes 3, 4 minutes, right? Every month. Just type your name into Google, type your name into social media. Just make sure there's no one else out there impersonating you, trying to use your likeness, your license to put out listings that aren't you, and use your likeness to do bad things. Um, I also encourage all of you in that respect, make sure you lock the tools of your trade, right? Contractors, when they go on a job, right? General contractor, any kind of contractor, do they leave their trucks unlocked? Do they leave their tools out in front of a house before they go in? No. They make sure that they're protected. You need to do the same thing. Lock all of the tools you use. Make sure you're using things like multi-factor authentication, changing your passwords regularly for things like your MLS account. Anything that a scammer could basically use to get into and create the persona or likeness of you. Make sure that you have those locked down so that nobody can get access to them. As far as your use of AI, I think brokers should certainly have policies. Make sure if you're a broker, if there are AI tools that you want your agents to use or approve them to use, that, again, if it's used for advertising, brokers have oversight responsibility for all advertising. So you have a right legally as a broker, even though your agents are independent contractors, to specify what approved tools they can use for advertising when it comes to AI. Um, Also, never use AI for contracts or legal advice. I encourage all of you, if you're going to use AI for any kind of content like photos, make sure you have a standard disclosure that lets consumers know that this image has been AI enhanced, right? If you're going to enhance images, provide the original and the altered image side by side or linked. And specifically when you're going to use things, just to photos side by side or linked, here's a good example of that standard disclosure, that standard disclaimer. Say that it's digitally enhanced, AI generated, virtually staged, whatever it is, but have that standard caption so it makes it clear to the consumer that this is a AI enhanced image. Certainly, you never, ever, ever use AI to misrepresent a property's core condition, hiding defects, using it to replace, move, modify structural elements. You want to be transparent. AI can be great to let people know what a property might look like, but you also have to let the consumer know what the property does look like. And if you're doing anything to deceive or even potentially deceive a consumer, you're exposing yourself to liability. So just please be careful, especially because Department of State put that warning out. I just wanted to be front and center on your radar that this is something that they're looking at. So you should really make sure that you're, paying attention when it comes to the use of AI. I'm going to cover two other new laws. Just that they don't really impact everyone. They impact certain types of transactions, but you should definitely be aware of them. And the first one is a new law on what the state calls unfair real estate service agreements. So there is a New York law just signed into law in December, goes into effect in March, and it prohibits unfair real estate service agreements. So, what is that? Um, Unfair real estate service agreements are basically listings that can't be performed within 2 years. So, any listing that is more than 2 years is considered now by law to be an unfair real estate service agreement. So what does that mean for you? You can't have any listing agreements for residential listings that have a term of more than 2 years. Haven't seen many like this, but there have been reports, and that's what prompted this legislation. Some individuals that were trying to basically lock in people to listings that went in very far in excess of 2 years. But the law now in New York, as of it's going into effect shortly, is that you cannot enter into a listing agreement for residential listings for more than 2 years. Um, Residential real estate is defined as real property located in the state, used for personal, family, or household purposes, and is improved by a 1 to 4 dwelling unit, including condominiums. So this does not apply to commercial listings, does not apply to vacant land. But any other residential listing, you cannot have a listing agreement that has a term of more than 2 years. Um, there can be penalties for non-compliance. The Attorney General is authorized to enforce this. They can bring an action to stop violations. There can be additional fines for each violation. So certainly something that you do not want to engage in. But just wanted to make you aware of that new law. Another new law, there is a new 90-day waiting period for certain sales to certain institutional investors. I'll explain what that means. Again, this one's not going to apply to all of you, but you should have it on your radar if you're dealing with any institutional investors. Here's the cite to the law. This law did already go into effect in July. Also covers residential property. This one defines single family and two-family residences, and it's sales to certain covered entities. So, what is a covered entity? It's a real estate investor or entity that receives funding from an institutional real estate investor. A loan that's a mortgage is not considered an institutional investor, provided it's the type of mortgage the general public can get. Doesn't include 501(c)(3)s, land banks, community land trusts, those types of things. But basically, if there's going to be an institutional real estate investor, there is now basically a waiting period. A covered entity, meaning an institutional investor, cannot purchase single family or two family residences unless it's been listed for sale to the general public for a period of at least 90 days. That 90-day waiting period restarts if the seller changes the asking price for the property. And covered entities that violate this law can be subject to civil damages and penalties in an amount not to exceed $250,000. So the intent of this law, you've probably heard it. There's concerns that some very large institutional investors are buying up chunks of single family and two family homes and preventing access and limiting the supply of homes to your traditional buyers and the individual buyers. So a number of states, and now New York is one of them, have passed laws that either limit or restrict the ability for these large institutional investors to buy properties. Yeah, somebody, Amanda asked, so basically BlackRock example. Yes, BlackRock is an example of one of those large institutional investors that at least nationally has reportedly bought up large chunks of individual residential properties and then tried to package them and sell them. So the goal of this legislation is to prevent that from happening. So there's now the property has to be at least listed for 90 days in order for that entity to purchase. There's also additional requirements if that covered entity is going to make an offer. They have to submit to the seller or seller's agent a signed form. It's a statutory form. It has to be notarized. It can't be modified. And then within 3 days of submitting that form, the entity has to file the form with the Department of State. And if they don't do that, there can be an additional fine. So what does this mean for you? If you represent these types of real estate investors, again, I think it's a very limited percentage of you, but there may be some out there. If you represent large real estate investors covered under this law, you've got to make sure that offers on their behalf for one and two family homes aren't made for at least 90 days from the date of the listing or from a price change. And that you also have to make sure that they submit that required form to the seller and to the Department of State. So, Amanda's got another question about this. This this is a New York State law. I know what you're talking about. There's a question about New York City and a different law that I'm not going to get into that. That law in New York City is different. It hasn't passed. It was actually put on hold. Mayor Adams rejected that or vetoed that law on his way out. And it has not been brought back up yet before the New York City Council. So this is a New York State law. This applies throughout New York State. Again, this applies just to the institutional investors. We'll cover the New York City law if and when there is a new law, but right now this is a New York State law only. So yes, this would apply also in New York City. State laws apply in New York City as well. New York City laws only apply within New York City, but this is a New York State law. It applies to all properties in New York State. Um, I I'm gonna move on. I don't want to get too hung up on this particular issue. If there are questions, we can talk about it at the end. But I've got a couple more topics I want to just get to before we finish. I do always like to spend a few minutes on lawful source of income discrimination. And I'm going to cover this quickly, but I do like to cover it in every legal update. Um, and the reason why is it's still the number one area of testing. It's the number one area of undercover testing when it comes to fair housing in New York. And it's also an area where we still continue to see violations by real estate licensees. Um, so, lawful source of income, for those of you that don't know, it's a protected class in New York. Um, I, as a housing provider, can ask any question about income. I can ask you where your source of income comes from, and I could ask you for proof of that. I want to know, can you pay for housing, right? That's fine. That's not discrimination. But I have to accept every type of income, every lawful source of income equally. I can't favor one form of income over another. That's where the discrimination occurs. So you look, here's just a list of all the different lawful sources of income, right? Just and employment is also a lawful source of income. I can't favor one form of income over another. The big area where we see discrimination is often on those last two bullets, which are housing choice vouchers or Section 8 or some kind of public assistance. So I can't say, well, I like Dawn better as a prospective tenant because she has a job versus anyone else who gets their income from one of these other sources. That's discrimination. You have to treat all forms the same, and you have to look at all individuals the same, regardless of where their income comes from. And these are the examples. Look, I could, these are just a few within the last year and a half, and I could pull more. It continues to be a problem in our industry, and there can be substantial fines for violating the lawful source of income laws. So please, please, please make sure that you understand this. And when I say understand it, any of these things are discrimination. It's not responding to a voucher holder's inquiry. It's telling a voucher holder, I don't work with voucher holders, or I don't work with landlords who take vouchers. That's discrimination. It's no different than saying, I don't work with people of this race, this religion, this gender. Just substitute any other protected class. It's discrimination. Telling people there's a wait list. If a landlord tells you they don't want to accept somebody with a voucher, you can't work with them. Period. End of story. Stop the relationship. It's that easy. Just end it. Um, and that's I cite this as a recent case. Basically, that's what happened here. There was a landlord who didn't want to work with somebody, and the agent continued to work with them. That's violating the lawful source of income laws. Um, Posting listings that say vouchers aren't accepted, not responding to people who call saying they have a voucher. That's considered discrimination. Um, so really easy to avoid it. Just have standard procedures in place for all tenants. If you're going to handle rentals, handle every inquiry the same way. Everyone who calls, every prospective tenant, have the same questions. Ask them where they're looking. Ask them how many bedrooms they're looking for. Ask them what their price range is. And if somebody says they have a voucher, you don't turn them away. You ask them, okay, well, what's the price range within that voucher that you can that the voucher is willing or able to cover? That's it. You're going to send them and show them all of the prospective properties that you would anyone else based on their income. Very simple. Again, we covered this already. Don't work with anybody who won't accept vouchers. You cannot abide by an unlawful instruction. And I will tell you, if you do, and you're reported to Division of Human Rights, Department of State, they look at violations for lawful source of income laws very strictly. The penalty is either suspension or revocation of your license. It's not going to be a fine. There's kind of a zero tolerance policy at this point for this type of discrimination. These come up a lot, questions about credit checks and income requirements. If the voucher covers 100% of someone's rent, that's it. There's no way a landlord cannot and should not look at credit, cannot look at income. That's it. The government's already said this person, based on the voucher, can afford that rent, period. If the voucher's only covering a portion, credit can be considered on a case by case basis, but you have to be careful because requiring a minimum credit score can still violate the source of income discrimination laws. Vouchers holders often have little or no credit. That's why they're getting a voucher. And more often than not, the vouchering agencies already determine that that prospective tenant can afford an additional amount. They've already done the analysis. So, if a landlord's going to require credit in that instance, it may trigger an investigation by the state or city human rights commission. All right, I'm going to wrap up in the last few minutes just to cover a couple of things related to advertising. We've got about 5 minutes left. I do want to cover a couple of things related to advertising, kind of things that come up frequently. I've also provided you a couple of handouts that I encourage all of you to look at after class. And I encourage you to look at them regularly. The most important one being the advertising checklist that comes straight from Department of State. So it's really, I think, a good practice for all of you to get into every, I'd say, 6 months at least. Take a look at all your advertising. And advertising includes everything. It includes your email signature. It includes any websites that you have. It includes your social media. It includes print ads, billboards, you name it. You want to wrap your car in something related to your business. That's advertising. Um, Go through the checklist and make sure that you're following the DOS guidance. It's the same checklist that Department of State would be using if you're called in for a violation. So any reported violation, typically Department of State, regardless of whether it's an advertising violation, let's just say somebody makes a fair housing complaint against you. Um, Department of State will separately, even if they clear you for that violation, they're going to look at your advertising. They're going to look at everything related to your website, your online presence, your social media, your business cards, and they're going to go down that checklist. So that's why I strongly encourage all of you to just do that yourselves regularly. Keeps you in compliance, also makes you look more professional. Um, Two areas I want to talk about. The first one is just proper use of names and titles. This one comes up a lot. Um, some of you have nicknames. That's great. You can use them, but your full license name must also appear in your advertising. So James Smith, make sure if he's goes by Jim as his nickname, it should be James Jim in quotes Smith. You need to have your full name. You also need to include your license title. This is a big one. I've seen websites, that broker websites that have this wrong, and the broker can be fined for each licensee that they're reporting it wrong. And believe me, it happens. I've gotten reports of brokers who had 30, 40 salespersons in their office and they listed them all as real estate agents. That could be 30 to 40 fines of $500 a piece. It adds up quickly. Whatever your license title is, real estate salesperson, associate real estate broker, that's what should be on your business card, your website, your social media page. Use that as your title. Don't use anything else. So simply using sale licensed agent or broker or licensed realtor, that those are not what your title is. Use the right title. Corporate titles can only be used by the broker of record. So your broker may call you the vice president, but you should not. If you're not the broker of record, don't put that in your advertising. They can only be used by the broker of record. Um, Associate real estate broker salespersons are not permitted to advertise themselves as corporate officers. And there's no distinction in the commercial world. Commercial brokers, commercial salespersons, you have to follow the same rules. I know for some reason it's like commonplace in the commercial world to have a title. It's unless you're the broker of record, you should not be using a corporate title. Another one, address and phone number rules. This one's important. Again, it could be you make this mistake, and you report to the Department of State, you're going to have to pay a fine. Um, Advertisements, you need to include the name of your broker and then either the full address of the brokerage or the telephone number of the brokerage, one or the other. So you have to have the name and then either the address or phone number in your advertisements. I've seen a lot of advertisers out there, social media, where they don't include either. Some don't even include the name of the broker. That can be multiple fines. Business cards have to include both. So, business cards, make sure that you have the name of your broker, but also the business address and the phone number. So, a little bit different. Advertisements, it's one or the other. Business cards, you have to make sure that you have both the address and the phone number. So, please make sure, check that checklist because it's very easy to make a mistake and it can be costly. So before you redo your business cards, before you pay somebody a boatload of money to redo your website, make sure that you just check that checklist. Last point, just teams. Teams have to advertise in the broker's name. Teams are not a separate legal entity. I know it's a lot of teams feel that way, and maybe they think that way, but it's not legally. Teams have to include the name of the broker. Um, and there are specific ways that the team has to advertise. They have to use the term team. Use of any other term, such as associate, realty, group, is prohibited. Use of a name of a non-licensed individual in a team name is prohibited. If you've got questions about teams, we have a whole host of resources on our website about team advertising. And just remember, if you're a broker, you are responsible for the team's activity. You can be disciplined for a team's activity. Teams themselves can't take listings. Teams cannot issue their own agreements for individual independent contractors. They can't basically enter into any agreements. They are not a legal entity. Teams are an extension of the brokerage. So the team can't say they have listings, only the broker can take listings. So please just make sure if you're a broker, you have to be exercising oversight over teams. And if you're not, and a team is disciplined or an individual from a team is disciplined, the broker can too. So just be aware of that as well. Um, that concludes the class. I know I covered a lot. Slides will be available on our website. And again, a lot of these materials, a lot of these topics are covered in a lot more depth on the website. So please make sure you visit. Already up there. So you're free. Once you answer the poll, you're free to leave. Thank you, everybody. Appreciate everybody's attentiveness and good luck clearing the rest of the snow.